Aye.
Good afternoon.
Good afternoon.
We just met a minute ago, but again, my name is Michael Sasso. I'm the chairman of this JNC. The way we're going to proceed, you've been here before, I'll just go over it again. The way we're going to proceed is all the commissioners will introduce themselves. I have one commissioner who is not here. She may or may not jump on a speakerphone. That's Commissioner Amanda Perry-Carl. And after that, we'll give you an opportunity to make an opening statement, however you want to describe it, a couple, 3-4 minutes. And then we'll have questions and answers. And about the 23-minute mark, I'll cut off Q&A and give you an opportunity to make some closing remarks. So,
Good afternoon, Your Honor. Vincent Citro with the Law Offices of Horowitz and Citro.
Good afternoon, Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bardos with Gray Robinson.
again, Mike Sasso, Sasso and Sasso, and I have Amanda Perry-Carl on the phone.
Rhett Retton with Schutz and Bowen in Orlando.
Good afternoon, Your Honor. Petra Brownlee with the Brownlee Law Firm.
Hello, I'm David DeArmas at Kramer Price and DeArmas in Orlando.
Your Honor, Scott Thomas with Bird Foreman.
Good afternoon to all of you.
Go ahead, Judge.
Thank you all for allowing me to be here. I have appeared before you previously, and I don't want to bore you by making the same opening that I made last time, so I have changed it a little, although I would assume that most of you have probably forgotten my previous opening remarks. I grew up in Homestead, Florida. I am the oldest of 4 children. I was raised by a family. My parents were very hardworking. They were not college educated. And so I was raised learning or thinking that I didn't have an opportunity to have college. I thought college was something for people that had money. So I started working at a young age. At age 13, I started babysitting to earn money for Jordache jeans and to go to the skating rink because I knew my parents didn't have money for luxuries like that. And then throughout high school, I worked 2 jobs so that I could save up money to buy my first car. When I graduated from high school, I just kept working, and one of the jobs that I had after high school was working at an orthopedic surgeon's office. And at that office, I started as a receptionist and then was promoted to the workers' comp division, where I was responsible for scheduling compulsory medical examinations and working closely with lawyers and the doctors to get them to write their reports and to make themselves available for deposition. And through that process, I came to realize that college was an opportunity that we all have, and that there was financial aid available. And so I started looking into how could I go to college and get an education and live a better lifestyle, the kind of lifestyle that I saw these doctors living. And so through that, I started married my high school sweetheart, and became pregnant with twins and researched how to go to college. And while I was 6 months pregnant with the twins, Hurricane Andrew struck and devastated the area where I lived. We lost our house and our car. I was 6 months pregnant with twins, which is a high-risk pregnancy. So we relocated and moved to Gainesville, Florida. And I actually started college at Santa Fe Community College in the summer of 1993 when my twins were 6 months old. Went straight through, I started nights and weekends and transferred to UF and then UF Law. My children were 3 years old when I started law school. They were 5 when I graduated from law school. We moved back to Miami after I graduated from law school. I worked for a year as a civil defense attorney in Miami. And we decided that Miami was a little too busy for us. We wanted a more laid-back lifestyle. Moved back to Gainesville. And I've been in Gainesville ever since. Practiced as a civil defense attorney for 16 years. Loved doing that. And then in April 2015, I was appointed to the circuit bench by Governor Scott. So I've been serving in Alachua County for 4 years, 2 years on the family bench, and 2 years on the circuit civil bench. I love being a judge. I love serving. And I look forward to speaking to you about the college opportunity. Thank you.
Your Honor, Amanda Perry-Carl, who's on the phone but not here, emailed me some questions because she vetted you, did a deep vet on you. We all, of course, look over your application and everything. So here is a question that she asked me to pose to you, and I'm just going to read it verbatim. She said, a couple of your references stated that they are much more equipped to provide a reference for you now than they have been now that you have been on the bench for a few years. They stated that the first couple of times you were newer to the bench, and that while they could say amazing things about you personally, intellectually, and as an attorney, They were not able to give specifics about you on the bench, as you hadn't been on the bench very long. However, they stated that now you have been on the bench for a few years, they can provide specific details about your judicial temperament, philosophy, and abilities on the bench. They had some great things to say, including one of your references who is a mediator. I really appreciated my conversation with him regarding the fact that as a mediator, he hears a lot of information about judges' demeanor, how long it takes them to rule, and philosophy. He stated that he has heard nothing but amazing things about you. So I want to commend you for having that reputation. Having said all of that, now that you have been on the bench a little while longer than the last time we saw you, how do you think that you have improved or matured as a judge? Whether that be organizationally, intellectually, philosophically? Sorry, this is a long question, Amanda.
It's a very long question.
So how do you think that you have changed?
I hope that I have improved in all of those areas, and that's my goal. I think that's all of our goals is, every day that we do something, we get a little better at it. And I think I'm more patient than I was. I think for the first couple of years on the bench, I came to the bench thinking everyone practiced law the same way that I did. Everyone had their formula and everyone followed the rules. And so there was some frustration realizing it sitting on the other side of the bench that not everyone follows the rules, not everyone knows the rules, not everyone plays by the rules. And so there was a level of frustration with that, and so I think I've learned to deal with that better. I'm always seeking to make the process better and looking at just ways that I can improve things. As a litigator for 16 years, when I took the circuit bench, one of the things that I did is I said to the other judge, there are 2 circuit judges that serve in Alachua County, and we each take 50% of circuit civil cases. And usually we set our trials at for the same trial docket, so we'll have 3, 4, up to 6 cases going at the same time. So we do venire, and usually the way it has worked is one judge gets up there and does venire. They separate the jurors out, and around 10:30, the jurors are going to their separate courtrooms, and then you have the attorneys come in and you're starting voir dire. So I talked to her, and we agreed that we would both do venire. So if her case settles, we still have 2 judges up there doing venire. We can get it done in half the time, so that maybe by 9:30, 9:45, we have those jurors in different courtrooms and we're able to start voir dire. So little things like that don't seem big, but I think they make an impact. I think it cuts down on the attorneys sitting around being nervous on the first day of trial. It helps their clients cut down on having to pay bills. So I'm just looking for little ways to make things more efficient.
Thank you.
Commissioner?
I've got to ask you the obvious question. How'd your 2 twins end up in Missouri?
Well, that would be a big mistake on my part, because when my son Michael, who was born a minute before Chris, at age 16, started talking about wanting to be a lawyer, I said, no, you don't want to do that. So he ended up deciding he wanted to be a farmer, and he decided that he could farm better in Missouri than Florida. So he is a firefighter. Both of my sons are firefighters, and Missouri was the location there. My husband's brother lives, and we had looked at buying land there a few years back. And so he said, well, maybe one day you'll end up in Missouri. So I'm going to go buy land in Missouri. And so he moved to Missouri. He's a firefighter and a farmer. He has 120 acres and 100 cows, and he's operating a dairy farm and is thrilled. And then his brother Chris, who's his twin, missed him immensely and decided to move to Missouri too. And so now I spend all my vacations in Missouri.
Why did
Their
you
dad's
tell
a farmer.
Yeah.
I figured that.
Yes.
Why did you tell him he didn't want to be a lawyer?
I just thought, being a lawyer is such a demanding occupation, and it was just it just can become so consuming that I just, it wasn't like a deep conversation, that was just my reaction, and he took it to heart. And now I say, I wish I had said yes, be a lawyer, and you could be in Florida. Now I do have a 10-year-old daughter right now who says she wants to be a lawyer, and I'm encouraging her.
Your Honor, we've met before through this process. I think I saw from either your application or maybe just from the paper you've also applied for the first DCA opening. You clearly have a significant interest in the district courts of appeal. What drives that?
I I love the law, so I always have. I'm such a legal nerd. Not only do I like being in the courtroom as a judge, I loved being in the courtroom as a lawyer. I read legal books for fun. I watch legal movies. And so the thing that appeals to me about the appellate level is the ability to read the cases and analyze the cases and write opinions. At the circuit civil level, which I do love, I spend so much time in the courtroom. I'm in the courtroom all day, every day. I'm having hearings. And when I have complicated hearings, I have to reserve ruling. I have to set that aside. I'm looking at cases on the weekends and in the evenings so that I can write a good order. And so to me, it's just the appellate level is appealing to me. It also gives me the ability to serve a larger community than I'm serving in the 8th Circuit, and just to spend time doing what I love.
In your current position, what role did you have in selecting the divisions that you served in? Or is it just every circuit does it different, so?
The 8th Circuit is such a great circuit. The chief judge, he makes the assignments, and they usually, before they make assignments when there's a new judge that comes on board, they kind of feel out all of the judges. We have 23 judges in our circuit. There are 12 circuit judges. And so they kind of get a feel for where you want to be and where you would be comfortable. Family is usually the first assignment, so I had a 2-year family assignment. When I took the bench, we had 2 long-serving circuit civil judges, Judge Monaco and Judge Holzlander, who had been in those positions forever. And so when Judge Holzlander retired, Judge Brazelton moved from family to civil. And then when Judge Monaco was close to retiring, they asked if I would be interested in the civil assignment. Of course, I said yes, I love civil law. And so that's where I'm at. We have a lot of judges in our circuit with criminal backgrounds, and so they feel comfortable serving there. But they really do try to keep us happy, so that could change at any time.
If you were appointed to this position and you were about to choose law clerks, hire law clerks, what are the qualities that you would look for when you were hiring a law clerk?
I would look for a law clerk that is hardworking, that is detail-oriented, someone that is going to carefully read those cases, someone who can write a good legal memorandum, analyzing the cases, and then someone who would feel comfortable making a recommendation. I have had law clerks in the past who, they'll write a 5-page memo and say, it's not clear, you could go this way or you could go that way. So I want someone who feels comfortable analyzing the law and providing a strong recommendation based on that.
Is there a past or present appellate judge or justice in Florida that you particularly admire and who you would want to pattern yourself after if you were appointed to this
Sure.
position?
Justice Alan Lawson, I think, would be my top choice at this point. He has such a great demeanor and he writes such well-reasoned opinions. It's just, I would strive to be like that.
Is there an opinion that he's authored recently, or one that comes to mind that you thought was particularly well-reasoned?
And I talked about this last time I was in front of you, was the Worley opinion. He wrote the dissent, and I agreed with him in his dissent in that opinion. Recently, in regarding the Civil Rules Amendment, where they changed the standard from Daubert to Fry and now Daubert. Again, I didn't agree with his reasoning, so I don't agree with his opinion. I would agree more with Justice Luck's opinion in that case. However, his opinion was so well written, and I found myself, even though I didn't necessarily agree with the opinion, I thought, well, I see where they're coming from. This makes sense.
So you think Justice Luck got it right?
I do, and I love the way he wrote his opinion too.
What do you think about PCAs? I know it's different being on the bench, but you did a lot of time. First question tied to that: how many appeals were you personally involved in practice, and then what was your experience with the PCA process as a lawyer?
So as a lawyer, I didn't have very many appeals that I handled. I probably wrote 2 appeals, 2 appellate briefs that I can think of, and I was affirmed on one and reversed on one. As a judge, I've had about, I think maybe 30 appeals, somewhere in the neighborhood of 30, and I've been reversed, I think, 2 or 3 times. And as far as how how I feel about PCAs, on my way here today, I got an email from the EDCA that one of my cases had been affirmed, so I was happy to see that, but it was PCA. And I, as a judge, you want to know, why was it PCA? This is a case that I've spent a lot of time looking at the law and carefully crafting an opinion based on the facts. And I think it would be helpful to have less PCA opinions, but I understand that given the volume of the cases and the amount of work that goes into it, that PCAs are necessary.
We, as practitioners, we talk a lot about PCAs, and we tend to complain maybe the judges don't write enough, but is there maybe a concern sometimes judges write too much? Do we always need concurrences? Do we always need dissents?
I don't think we do. I don't think we do. For example, the case that was just affirmed, it was affirmed. That answers the question for everyone. And I don't know that it would have added too much to have a written opinion.
What about the idea that some jurisdictions and even the 11th Circuit will write an opinion in every case, some of which are published and then some of which are not, and therefore aren't binding necessarily? Do you think that that's a better approach or a good approach as compared to how Florida does it with the PCAs?
I think it gets confusing when you have a lot of long written opinions that aren't binding, and then, as it is right now with binding case law being presented to me, I get, a binder this big from each side when I have a motion for summary judgment, or I have a motion to dismiss, or I have a subject matter jurisdiction issue. So I think if I have a lot more opinions to read and they're not binding and they're being argued for their persuasive quality, it just, to me, it muddies the water.
So if, let's just say, one was to pull all of your decisions that have been appealed, right, and took a look at all of them, both those that have been affirmed and those that have been reversed. What would you think is the takeaway, understanding that you get, just like you did, congratulations, I don't have the PCA today, but, what is the takeaway that you would have regarding, the first DCA's guidance or items that they've sent back to you, or your affirmance on the cases that you've had?
Well, I think the fact that I've been affirmed without written opinions in the majority of the appeals, it means that I get it right most of the time,
Right.
which is my goal. Every time, I want to get it right, and I'm striving to follow the rules. Every case that comes before me, I'm carefully considering the issues. I'm carefully applying the facts to the law. I'm carefully weighing everything in front of me, and then trying to craft an order that will be affirmed on appeal, because I know I'm dealing with difficult issues, and it's important to the litigants to be able to see the reasoning. So I do take that time and do that and try to get it right. When I look at it, when I get an affirmance, I got an A, and when I get a reversal, I got an F. And maybe that's simplistic, but I'm always trying to figure out, what if I did get it wrong, what did I do wrong, and how can I improve?
Are there any cases, that stick out to you?
Well, I attached as my writing sample to my application, the order that I attached is the Amalgamated Trust versus City of Gainesville case, and that is one where I was reversed. And I thought it would be nice for you to see, if you read the reversal, you can read the underlying order and see what it was they reversed. I don't agree with the reversal. At least there was one dissenting judge who said that I got it right. And I think that you can see in reading my opinion how I laid it out. I think that what I do in every case is, if there's a statute that I'm to follow, I put that statute right in front of me, and I'm applying the facts to the statute. And then I try to write an order expressing how I did that. How did I apply the facts to the statute? And in that case, there was a statute. It dealt with, I entered an order vacating an arbitrator's award. When I looked at the motion asking me to do that, and I looked at the response asking me to do that, my initial thought was, I'm not going to vacate an arbitrator's award. Public policy is, we want to encourage arbitration, we defer to arbitrators, they can get the law wrong, they can get the facts wrong, and we don't vacate them. But the statute says, if they exceed their authority, they shall be vacated, and if they act with bias, their order shall be vacated. And so I carefully analyzed the record, I carefully looked at the facts, and I carefully drafted an order that focused on the arbitrary language and why I thought it demonstrated bias. The interesting thing about that case is that I watched oral argument, which I do if there's oral argument in the case, and you can't tell this from my opinion or the appellate opinion, but they did not have the video. There were two videos. This was a bus driver who was terminated for hitting two different patrons on the bus within a 48-hour period. And both of those incidents were video recorded. I watched the video, it was submitted into evidence. Apparently, when it went up on appeal, the video wasn't in the record. And so one of the judges asked the attorney, the defense attorney, is it important that the video is not in the record? And he said no. And so they ruled based on that. The video was very important to me because it showed the bias, that he demonstrated his bias by his description of the video in large part. If I had known that they weren't going to watch the video, I probably would have described what was in the video better.
What about PCAs often, I mean, they can be a situation where maybe the error that's alleged, maybe someone's clearly right or someone's clearly wrong, but the error is not sufficiently preserved, and that's the reason for the PCA, but nobody really knows, so the trial judge is assuming that they got it right, when in reality, it just wasn't sufficiently preserved. Do you think that there's a danger in that, in trial courts that, I mean, for example, say you were just PCA, you think it's because you got it right, but in reality, you didn't get it right. I'm sure that you did. But, you know, say though that they actually PCA because it wasn't preserved, and nobody knows that. Do you think there's a danger in that?
Sure. I mean, in a perfect world, I think there would be, you know, some kind of brief decision that instead of a PCA, some brief description, you know, it's being affirmed because this issue wasn't preserved on appeal. And then I think that would help us all. I wouldn't assume that I got it right, and the attorneys would know, oh, we have to be on the lookout to preserve this issue better. So I think there are a lot of instances where that would benefit us. But again, given the reality of the volume of the cases and the length of time that is spent drafting the orders, I just don't think it's practical. And I look at that from the perspective of a judge with 480 cases that I'm constantly in court managing these cases. And I would love to spend a week writing a report, and just as a practical matter, writing an order as a practical matter, I don't have the time to even draft the quality of orders that I would love to draft. I mean, I put in the nights and I put in the weekends to do it, or I have it sit there for an extra couple of weeks so that I can work on it when I can. But I would probably say that I've not had the opportunity to just draft the work of art order that I would like to work due to time constraints.
But the time constraints would be less if you were on the appellate.
Right.
Yeah.
What weight or credence do you give to legislative history when you're interpreting a statute?
I generally don't look at legislative history. I think we're required to look at the text of the statute. I think even the legislators, when they draft their statutes, a lot goes into that. There's a lot of debate, there's a lot of give and take. And if we look at legislative history, I think we can tend to disregard just the pure unambiguous intent of the statute, just looking at the language. We can muddy it too much if we get into legislative history too much.
If the statute's not a model of clarity, where would you go?
Usually,
And it's new, and you don't have the benefit of the decisional guidance.
I probably would look at the legislative history to get some perspective, but I'm not going to put a lot of weight on that. I'm going to look at dictionary definitions, if it's language that I'm looking at. I'm going to look at companion statutes and compare the language within the statute.
I you might have heard it wrong, but I believe that you were saying that it really wasn't necessary to have concurring opinions or dissenting opinions. The decision stands by itself. And then you came back at a later time and said you were so glad that the dissent went your way. Do you actually feel like they're writing too much in light of the fact that the writing too much really came to your benefit?
No, I don't feel like they're writing too much. I think if we're, I think my my answer was in response to the 11th Circuit writing opinions that are persuasive and not binding. But I don't think they're writing too much.
Anybody else?
Your Honor, I couldn't help, I hadn't looked it up before, I couldn't resist looking up the DCA opinion on the arbitration thing, and I do know that they certified conflict on whether it was even reviewable in the first place, so. Beyond the merits, there's that.
Although they all agreed that it was reviewable.
Right, but they.
But they did
conflict with it,
certify
yeah.
conflict, yes.
Well, I'm a fan of arbitration also, but you do have a constitutional right to a trial.
You do. And it was interesting, it was a Gainesville case with an Orlando, I think there was an Orlando attorney and an Atlanta arbitrator. So they arbitrated a Gainesville case in Atlanta. I just thought it was interesting.
Okay, well, thank you. That will conclude the question and answer portion of the interview, and we'd love to hear anything you might say to us.
Well, thank you all for having me here, and it's an honor to be here. I want to thank you all for serving on the JMC. I know it's a huge sacrifice for you as far as your time, and a lot of time and energy goes into that. I hope that I've answered your questions so that you would feel comfortable sending me up for consideration by the governor for this position. I can promise you that if I am sent up, that I will continue to work hard. I will continue to follow the law, and I will continue to do my best to serve our legal community every day that I'm on the bench. Thank you all.
Okay, thank you.
Thank you.
Thanks for coming. Thanks for applying.
Thank you.